Hey folks, I'm attorney Roger P. Foley. Today I'm going to talk to you about pro se litigants. What is a pro se litigant? A pro se litigant is someone who represents themselves. They don't hire an attorney. They don't request the services of a public defender. They decide that they can do it better. They're going to represent themselves. They know what happened. They're going to present their case to a jury. Okay, that's what pro se is. Now, you've heard about, I can't tell you how many conversations that I've had with people where they say, oh my goodness, this person I can't believe that they got off. Oh my goodness, the criminal system lets everybody off. Oh, that person got acquitted of murder. Oh, that person, burglarized. Oh, that person had a DUI, they got off. Yeah, and they had an attorney. So let me tell you, have you ever heard, think about this, have you ever heard, and I'll probably search it right after I do this video. Have you ever heard, because I haven't in 15 years of being a criminal defense attorney, I've never once seen someone at the courthouse represent themselves and been acquitted of the charges, found not guilty. I've never heard of anyone. I've never seen a newspaper article. I've never seen it on the news, and I've never seen it on a YouTube video. I don't know, maybe there's somebody, but the clear message here is do not represent yourself. If you don't have the funds for an attorney, talk to the public defender, request their services. If you have the money, hire an attorney. Why? Because it's important. Could you imagine breaking your arm and instead of going to the hospital saying, let me just set my arm myself. Let me just set my arm myself and cast it up and get some newspapers and some clay and kind of put it there. What do you think is going to happen 4 months later? Your arm's going to be still broken. You're going to have to go to the hospital. You're going to have to even spend more money. You're going to have surgery. They're going to have to break it and reset it. Think about it, folks. This is your life. I want to talk to you about this Minnesota man, right? This Minnesota man was charged with DUI, and he decided to represent himself. Oh, so what happened? Well, I'm going to tell you. I'm going to come down here, and I'm going to show you the article. You're going to see that this gentleman is from Minnesota. He got charged with DUI. I'm going to tell you a little bit about the facts, but you can read them right here on the page. He's stopped for DUI. He's going 100 miles per hour. The officer is behind him for approximately 10 miles. As you read this report, now it's not the police report, but if you're doing 100 miles per hour and you're going down a highway at 100 miles per hour and you don't cross over the lane, you don't crash, you don't go hit the side rail, that's probably a pretty good indicator that you're not impaired. Yes, some people will disagree with me, but 10 miles at 100 miles per hour and he didn't crash, he didn't go off the road. There's nothing in the article that says that he left the lane of travel. He didn't go in the opposite direction. That's a pretty good cross-examination for me as a defense attorney. What else happened? Well, when he pulls over, they say he rolled down his window. That's one of the questions, folks, that I ask every single officer. I say, officer, you put on your overhead lights? Yes. And the defendant pulled over? Yes. And he pulled over into a safe area? Well, I don't know what you mean. Well, did he pull over on the shoulder or did he stop in the middle of a highway? No, he pulled over to the shoulder. And that's what he's supposed to do, correct? Yes. And as you approach the vehicle, he rolled down his window? Yes, he did. You got to think he's got to have some cognizant ability, right? His mental faculties have to be working if he pulls over appropriately, if he rolls down the window, officer, did you asked him for his driver's license, registration, insurance? Yes, I did. And he gave you his license? Yes? Yes. He gave you his insurance? Yes. He gave you his registration? Yes. And he didn't fumble. He didn't hand you a library card by accident. No. These are the techniques. And this is very basic, folks. This is stuff that I'm giving you, some stuff that's, a first-year lawyer would do. I just think someone who's been doing it 15 years, 20 years, 30 years. We develop techniques. We continuously take continuing legal education courses. So let's go on. So the jury finds him guilty, but let's go down to the facts here. When he's pulled over, he rolls down the window and he says, I reserve my Second Amendment rights. The officer noted that his eyes were slightly bloodshot. Well, I don't know. Well, it's cold in Minnesota. Maybe he's just outside, right? Maybe it's windy. Maybe he has something in his eye. Maybe he has a cold, right? it says slightly bloodshot and watery. And then the officer handcuffed Stevenson and took him into custody. What facts do we have here, folks? Maybe this gentleman thought that his case was so easy, but the state went forward and they convicted him. It says, according to the complainant, Stevenson screamed and swore as he was transported to the jail. Well, I'd like to know what he was saying. Well, he said he was going to kill the person he believed had called the police. Okay, but was he saying, I'm innocent? Like, I'd like to know a little bit more, but, that's not a good thing. You never scream, kick, spit, fight with a police officer who's going to arrest you. Let him arrest you. Your fight is in court with your attorney. It says he refused a breath test. Instead of calling an attorney, he used his one phone call to call his girlfriend. Probably not the smartest move. Well, then it says that he tried to ask the District Court of Appeal to subpoena the records and denied the request. Had he hired an attorney, had he contacted the public defender if he didn't have money, as an attorney, we would have requested the documents. We would have requested the jail cameras. We would have requested information about the Intoxilizer 8000. That's the machine that's used throughout the country. We would have asked for any witnesses, anyone who was there, the breath tech. They have someone called the breath tech, whoever was there. And we would have acquired those records quite easily. I mean, not too much effort. Yes, you have to file a motion with the court, but it's part of discovery and you're entitled to it. So this gentleman really made, I got to tell you, quite a big mistake. Whoops, not using an attorney. He really did. He chose not to use an attorney. He was found guilty. And the Court of Appeal, oh, this is the big thing that happened. Listen to this. Because he doesn't know the rules of evidence, because he doesn't know court rules, because he doesn't know how the process works, the state attorney introduced his prior criminal history, something that never happens. When you look at this report, right, that I was just showing you, this newspaper article, it said that he was charged with a DUI, that he was charged with a refusal, and he was charged with driving with a suspended or revoked license. Well, let me tell you this. Anywhere in the 50 states, your first refusal is sort of on the house. It tells me that he had a prior DUI. So think about that, ladies and gentlemen. If the jury knew that he had a prior DUI and that the officer thought he was DUI on this case, you think that would play into fact? I bet you do. If it says that his license was suspended or revoked, do you want the jury to know that? No, you would sever that charge. You would resolve that charge by plea independently. The jury hears, oh, he's had a prior DUI. Oh my goodness, he's driving on a revoked driver's license because his license was previously taken for DUI. Even if the evidence wasn't that strong against him, right? There was no breath, supposedly. There really wasn't any field sobriety exercises. What did they convict him on? They probably convicted him on his past. But what did the Court of Appeal say? Yes, that stuff shouldn't have been admitted, but they really had a strong case against this gentleman. Did they? I don't know. You read the article. I'm attorney Roger P. Foley. Never, ever, ever represent yourself, no matter what. Find an attorney, private attorney, public defender. Do your due diligence, and you will find the attorney that's right for you.